Good evening, everyone. Welcome to White Collar Week. This is our Tuesday night speaker series, and our special speaker tonight is Molly Parmer. I'll say a little bit about her in a moment. A few announcements before we get started. This is brought to you by our White Collar Support Group. Our White Collar Support Group meets every Monday at 7 p.m. Eastern, 4 p.m. Pacific. And you can find more information about us on our website at prisonist.org. That's prisonist like feminist, prisonist.org. And we hold a meeting every single week. This week, it will be our 430th meeting. So we've been doing it for over 8.5 years. And we've had over 1,100 people join our meetings, and we're in touch with many or most of them. So it's a community. So either if you're directly justice impacted, join us. If you're not, or your family friend, please contact us anyway, and we'll find a resource for you. And the other announcement I want to make tonight is on October 19th, we are going to be holding our White Collar Conference. First time ever, a conference will be held by white collar justice impacted people for white collar justice impacted people, and we're super excited about it. We're starting to post our schedule that has just so many wonderful people, professionals, and should be very informative, interesting, probably a lot of fun too. I hope so. That's October 19th, and you can get more information about that on our conference website, whitecollarconference.com. That shouldn't be too hard to remember for everybody, whitecollarconference.com. And we hope you'll join us October 19th. So tonight, our guest speaker is Molly Parmer. I am a follower of Molly on social media, which is how I found out about her. And she is brilliant at social media. I understand she's even more brilliant at lawyering. At least I hope so. Otherwise, we have you on the wrong program, Molly. But a super big win under her belt recently that we were talking about before this event. So I'm just going to read a little bit about Molly, and then I'll turn it over to her. Molly Parmer owns a boutique criminal law firm, Parmer Law, which provides high stakes defense to select clientele predominantly in federal court. Molly opened her law firm in 2019 and has office locations in Atlanta and Savannah, Georgia. In 2023, she spent 3 months in a federal criminal tax fraud trial where a government alleged over $400 million in loss. Molly's client was found not guilty of all charges. In addition to extensive federal trial experience, Molly also handles federal appellate matters and has presented oral arguments before the 10th and 11th circuits. Molly is a sought-after television legal analyst, frequently provides commentary on CourtTV, Fox, ABC, NBC, and other national news networks. I have seen her on CourtTV, and it's worth watching her go to work on whatever the issue of the day is. At any rate, I want to introduce Molly, and Molly, please take it away for about a half hour or so, and then we'll do questions and sharing.
Sure. Well, thanks, Jeff, so much for having me. It's an honor to be here. I've sent clients to the White Collar Support Group, and they come back raving about it. I think that this is so needed, and it's something that obviously can only be done by those that truly understand it. So it's such a noble and important effort, and certainly my clients have benefited tremendously. So I'm glad to be here. As you mentioned, I am a trial lawyer, mostly in federal court, exclusively criminal defense. I also am an adjunct law professor at Emory. I teach students in their third final year advanced criminal trial practice, both future prosecutors and future defenders. I do CourtTV every Wednesday for the most part. So tomorrow at 8 p.m. Eastern Standard Time, I'll be on with Vinnie Politan. And I do a lot of social media. At the end of the day, I think that, when I started my law firm, I was excited to kind of have a platform, because before that, I was an assistant federal defender. And before that, I was a public defender on the county level. And you certainly are not supposed to be talking to the media. And you're certainly not supposed to be, you know, broadcasting some of your maybe more controversial ideas, which is exactly what I wanted to do if I ever had the opportunity to be independent and my own boss. So certainly when I launched my firm, I kind of took it upon myself to talk a lot about, I think, some of the issues with mass incarceration, overcriminalization, unduly punitive systems that we have at play, and a lot of stuff that I had thought about for, you know, the many years I had been in public service before being in private practice. And I think, you know, I'll talk very little about the trial. I'll discuss kind of some general things just because I think it's appropriate to keep it vague for now. But in terms of my philosophy and my love of what I do and why I wanted to do this, I think it starts well before I ever knew I was going to law school. I had a very non-traditional childhood and incredibly non-conformist, like radical parents. And I think it helps me understand things from a different perspective, certainly, and it's made me a different lawyer. I know that for sure. But my first exposure to the criminal justice system were my dad's descriptions of being at the 1968 Democratic Convention with his friend Abby Hoffman. He illustrated Steelbus' book and was a member of like the Yippies and was there during the riots. He wasn't arrested with the Chicago 7 or the Chicago 8, but he attended every single day of the trial. And he's an artist. And so he would like sketch. He did a bunch of art to raise money for their legal defense. And so I was born in Chicago with parents that never really like left the hippie era, right? So some of the members of the Chicago 7 like moved on and got normal jobs. Like Jerry Rubin became a stockbroker, right? Not my parents. They continued to live as they lived in the late 60s, right? Total flower children, you know. And I say all of this. One time I spoke on a panel, a panel about voir dire at like my local bar association. It's the only time I ever had to block somebody on social media, and it was on LinkedIn because somebody found this very offensive. But it's not like you know, I'm very different from my parents. But I just share this because, you know, your parents do have some influence on you, no matter if you're similar or different from them, right? So it's not like I ascribe to the same beliefs as my father, who was unquestionably a radical, but I was exposed to that. And that shapes you from a very young age, where instead of being told that you have to follow authority, you see your father, your authority figure, you know, he had a tattoo that said "smash the state," right? Like, that was my dad. And, you know, he was also in and out of jail, right? And we were really, really poor because my parents didn't have jobs. They just, you know, they were doing art. And so I grew up in an arguably like dysfunctional home, but certainly philosophically, there was a lot of depth there, right? And we were encouraged, you know, my sisters and I, we were all like school was going to be the way out, right? School was going to be the way out. And so I remember vividly from a, you know, a very young age going to like kindergarten and being like, all right, this is what I'm going to do. This is my thing. You know, I'm glad to be out of this home life, and I'm glad to be in a space where if I can just do school, like I'm going to be okay. So that kind of became my thing, right? Like academics. I threw myself into academics, and that was encouraged. My parents, for all their faults, you know, they definitely knew that that was going to be something that was going to get me out of the situation of like poverty and dysfunction. So I ended up, my parents, we actually relocated from Chicago. How I ended up in Atlanta was that there was this scholarship program at the time when I was about to be in high school, the Hope Scholarship, state-funded, lottery-funded program, where if you maintained a certain GPA in high school, you could go to a state school for free. So we had like some family here, and my parents were like, all right, we're not going to be able to afford the kids being educated, going to college. So we have this opportunity to move to Georgia and they can go to college. So that's what we did. And in high school, I was, you know, working like 40 hours a week, attending like a community college in my last years, trying to get ready to be out on my own. And then I went to Georgia Tech because I wanted to go to the best school that I could go to for free. Now, I was not like a, you know, I'm not like, I was good across the board academically, but I'm not like a scientist. And so it was rough. It's a very rigorous, difficult school. But I think that's good training, right? For law school. It made law school a breeze. But after I graduated from Georgia Tech, I knew I wasn't going to be like a lab scientist or anything like that. So I actually ended up doing an alternative teacher preparation program, kind of like Teach for America. And I ended up spending 5 years teaching students with emotional and behavioral disabilities in Title I special education classrooms. And I look back and I think that that actually, much more so than the influence of like these like radical parents, I think much more so that kind of became the beginning of my interest in the intersection of, I guess, maybe law and like behavior, right? So I had these students who were placed like usually in a self-contained environment with me and two paraprofessionals, very severe, right? Very severe behavior disorders. And they were governed by like the Individuals with Disability Education Act. They had these IEPs, individualized education plans. And there was this intersection between like what the law says and what we're actually going to do in these school districts that didn't have any resources. And then I was kind of like the advocate for the kid who was allegedly misbehaving, right? And so I did this for 5 years and I really loved it for a lot of reasons. But of course, you know, there's a lot of reasons why teaching is really hard. And with No Child Left Behind, it was kind of the beginning of my kids having to take standardized tests. And so, you know, I had a lot of like, I disagreed with a lot of things that kind of the public schools were going through at that time from a special ed perspective. And I thought going back to graduate school would be easy. And so I decided to go to law school because again, I think I was interested in how the law was affecting these kids, right? I was like, I can get this. So I, you know, was like basically the working poor at that point. I was working 2 part-time jobs and teaching full-time. So I worked out every weekend, retail, and then I also in the evenings was tutoring and I was teaching, middle school for the most part. And I was lucky enough that I got a full tuition scholarship to Emory Law. So that was where I went. And I have been part of the Emory Law community ever since. They were very nice to me. You know, like when I decided to write my personal statement, it was strange and honest. And, they made it a point to kind of let me know that they wanted to support me. And I definitely needed support because I did come from such a different background than did a lot of my fellow classmates. So I go to this school and the focus really was a lot on corporate law, big law, and that was not what I wanted to do. But again, they gave me kind of the leeway to be myself. And I think I kind of discovered myself through those 3 years. I founded the Emory Law Criminal Law Society. I started to do, I was able to put on a symposium to train police and prosecutors about eyewitness identification at some point. They really let me kind of cultivate for the first time at a school that otherwise didn't have it, a focus on criminal practice. And so straight out of law school, I was hired at the local public defender's office and had an incredible experience. My first trial, I mean, I was second chair, but my very first trial was a murder, my first jury trial. And it was a shooting in a strip mall in a really bad part of the city in between like the Tanqueray Lounge and the Bread of Life Baptist Church, right? And it was a not guilty, you know? And that changed my life. Like that, I was done. If your first trial is a murder and you walk the guy, you have no choice the rest of your life. You're going to be a trial lawyer, right? So I worked at the public defender's office there for a couple more years. I, at the end, had a caseload of over 300 open felony cases and very little resources. And I just felt like that's not what I kind of envisioned myself doing. I didn't, I felt like I was sometimes making things worse. And I think that's something that all public defenders grapple with, right? Like, am I actually part of the broken system? Or can I fix it? And if you don't do systemic litigation, if you're just representing one person at a time and you're spread between 300, I think for me, I couldn't do that anymore. So then I had an opportunity at the federal defenders. I was, by far the least experienced person that they decided to hire. And I had an incredible female boss who had been the federal defender since like 1978, since she was like in her 30s, and Stephanie Kearns, and she kind of took me under her wing. And during my 5 years as an assistant federal defender, I learned so much. And that's when I really started to see kind of, I think, my first exposure to like white collar practice and a certain level of sophistication, the use of experts. You know, you have to be kind of resource rich. And my office was, because Stephanie ran it so well. And so if there was a, you know, a trial and we needed a forensic accountant, there was no question we were going to get one. So I learned this kind of different approach to trying cases. I learned, I think, how to do it the right way, right? It wasn't just trial by fire any longer. It was really like methodical and strategic and academic work. And we did this kind of direct representation, you know, vertically, where if somebody was arrested, brought to the US Marshals, you know, if this was your day, you were assigned that day to be the attorney on duty, you met the person, you met their family, and then you would take the case all the way through trial, and then you would appeal the case and you would do the oral argument. So we didn't have these different divisions within the office where you kind of hand off your client to somebody else. So I think that that kind of training was tremendous in terms of preparing me for what I do now when I do take cases all the way from arrest to appeal, or habeas or something else. So I was really grateful for that experience. Most people don't leave that office. You know, most people go there, they leave big law to go there and work there the rest of their lives. But, you know, I kind of always have done my own thing. And again, I had in the back of my head this idea to have a bit of a platform, you know, to kind of raise awareness on a level that I think as a government employee, you just can't, you're prohibited from doing that. And I still keep up with the federal defenders. They're just, you know, wonderful friends, and I'm certainly part of their community. But in 2019, I decided to go out on my own, and I launched my law firm. And at the same time, kind of did start getting more involved with various speaking engagements. For a while, I kind of, you know, I was really heavy into TV. These days, I've joined the board of directors of the National Association of Criminal Defense Lawyers. I speak at 4 or 5 of their conferences across the country. And I certainly do social media in addition to TV. And I think that, you know, again, what I'm trying to do is provide a voice that maybe has a different perspective for a few reasons. I think that academically and intellectually, criminal defense is so interesting when you actually break it down. I think that the nuances in the law are what like really kind of, you know, push the needle to a point where we see actual systemic change. And so I think sometimes if we remove ourselves a bit emotionally and talk a little bit more about things from an academic perspective, there's more understanding there. And then simultaneously, I think it's really important to humanize everything and talk about things from an emotional, maybe more visceral perspective. So I do a little bit of both in social media and when I'm speaking on television. But this really is my life in every single sense of the word. It's my identity. Like, I feel very lucky that this is my job, that I have the clients that I have. I've had some really interesting cases over the years. I represented for a period of time the Tiger King, Joe Exotic. If you know who Joe Exotic, the Tiger King is, I argued his appeal in the 10th Circuit Court of Appeals. So here's an example of like the academic side where you can kind of remove yourself from, like, for Joe, it's like this complete circus, right? It's just hilarious. So nobody wants to get down to like the actual facts or the elements, you know, underlying his conviction. But I argued that there was an issue with multiplicity, that if you have one plot to kill one Carol Baskin and there is no injury, which there wasn't, nor death, you can't run those sentences consecutively, right? That violates due process. And so we took that to the 10th Circuit, and they were very mean to me, and I lost. But it was an interesting issue, and I think it was one that had to be litigated, and I still believe that I was correct. But, you know, sometimes you believe you're correct and the court says otherwise. That happens to me every once in a while, you know? So I had that case, and I've had a few other really interesting professional opportunities over the years. I did some work with the Last Prisoner Project. They have a goal of kind of getting anybody who's serving life for a marijuana conviction out of confinement. I have, obviously, you know, last year I spent 3 months in trial every single day straight on the big tax fraud case. And that was really interesting too. I think, what I will say about that is that the attorneys that I worked with were by far the most brilliant minds I have ever had the privilege of being around. And I became a much better lawyer by going through something like that and seeing how those kind of people approach an incredibly complex, incredibly high stakes case. And, I think there's always just such an opportunity to learn in this job. And I like leadership, and I like, running the firm, but I will be the first to say that what I really like is kind of, I like admitting that I don't know what I'm doing half the time, and knowing that I have such an incredible community of people to go to brainstorm with, to ask questions of, and to hopefully become, a better lawyer with every single passing day. Like, no case is the same, no client is the same. And I've learned so much, and I know I have so much more to learn. And I think it's just interesting because lawyers sometimes have a reputation for, for ego, for being know-it-alls. And I think that for me, the practice of law has actually been the exact opposite. It's been a constant recognition that you can never reach the end of, research on a particular issue, or like, what's going to be the next thing. Like, I think, for me, I'm really interested in this recent Loper Bright decision. It's like administrative law and how maybe it can apply to the United States sentencing guidelines. Like, that's so exciting to me, right? Like, last year I was really into, see, Caroline is laughing, but like, I think that's so interesting, right? Like, how do things turn like that? How do things turn on a dime? Like, I think if you are kind of a curious person, if you're a curious mind, and if you kind of let go of the ego and just throw yourself into the practice, it's just one of the most, it's limitless in terms of what you can do, I think, as an attorney. But at the end of the day, I will say that my favorite thing is certainly my clients. I think that I've been around people that maybe they did it themselves, maybe somebody did it to them, but are somewhat marginalized, right? Maybe it was their own choices, or maybe it was their circumstances. But I have always been around people that don't quite conform to society's expectations, right? It started with my family, and then my students, my special ed students. And I just, even like these days, like, a lot of my friends, they have criminal records, and my sister has a criminal record. My dad died a fugitive, rather than he had a bunch of arrests and had some mandatory jail time here in Georgia. And so instead he just moved to Vermont, where they weren't going to extradite him, and like married somebody like a child bride and lived out his final days. I don't know, like that's who I've been around my whole life. And I will always prefer the company of somebody who maybe the rest of society looks at them and says, you're bad, you made a mistake, you're an outcast. No, I would proudly stand beside that person and advocate for them and for their human decency and, some sort of mercy, than I would like applaud somebody for doing everything right all the time. So I think for me, what I offer these days with my clients is like a really deep personal connection. Like, it's not like, oh, here's your case closing letter. It's nice to represent you. I'm glad we got a good result. Take care. I still keep up with pretty much everyone that I've represented in recent years, and all of their family, and celebrate their lives as they move on from their case, and probably should move on from their lawyer. But it is a deeply personal practice for me. And, I think it's for sure my life's work. And I also think I've just begun. So that's who I am, and that's what I've done. Let's see where I am on time. It's 7:34, so I'm not quite at 30 minutes. But if you have any questions, I'm happy to answer them.
Molly, thank you. It's so refreshing and wonderful to hear from a lawyer who is just as compassionate as you are, and involved. So I have a couple of questions, and we'll open it up to people. I just want to make sure I have this on the right view for the camera. First question. Most of us are used to most people who have been prosecuted for white collar crime are used to looking for or hearing pitches from lawyers who were prosecutors.
Oh,
And they kind of wear that on their sleeve. I was the bureau chief. I was the such and such chief. I and we feel many of us have learned over time, and I'm not quite sure where this came from, that that's a way to find a lawyer that's going to somehow have an in that particular U.S. Attorney's office. And I was involved in a case out in Northern District, California, with an attorney named Ed Swanson, he speaks at criminal
yeah.
at NACDL conferences, and he was a federal defender. And what I found from Ed is not only was he a very competent lawyer, but he had a kind of empathy that we generally don't find coming out of former prosecutors. That's not always true, but generally. And so I'm wondering how it kind of works for you being out there now and not necessarily being in the former prosecutor crowd, but having been in defense the whole time. Is that an advantage, a disadvantage, or people really are they not understand the way this all goes together? I mean, what are the benefits and maybe not such benefits of working with a former federal defender?
Right. It's interesting. I've certainly had potential clients kind of pose a similar question, right? And I always tell potential clients, talk to as many lawyers as possible. This is not like a light decision by any means. You have to connect with this person. And that should be the first consideration. And I think sometimes clients ultimately realize that someone who doesn't have it within them to ever consider being a prosecutor might be a better fit if what they need is a certain level of connectivity, right? So I could never be a prosecutor. I would be I don't know what I would be any other lawyer before I would be a prosecutor. But I will say that I have a really good relationship with pretty much all prosecutors that I've ever worked with. I think that, when you're a federal defender, you can't go in there and like burn it down, right? You want to, you have to maintain your reputation. You're going into the same courthouse every single day. And so if you walk into the courthouse with me, I do think that it's interesting. I think that sometimes I'm even better received than the prosecutors because as a personality, I think defenders are a little bit more social and bigger and less uptight. And so all the judges, clerks know me and all the security officers know me. And I think, so long as you're respectful to your colleagues, you're going to have the same connections that a former prosecutor has. I do also think that when it comes to trial, that defenders are trained a little better. And the reason is, prosecutors try more cases, certainly. But my understanding, and this comes from having many friends from the U.S. Attorney's Office, they're kind of confined, right? There are certain rules in terms of what they can say in opening or in closing. And, what I teach my students ultimately at Emory Law is to kind of, deprogram yourself a bit, because what juries, if you really listen to your feedback from jurors, if you really listen to what like the random assortment of 12 plus 2 people sitting in the box want, either for a conviction or an acquittal, it's not like this robotic, delivery and just matching elements to some quantum of proof, right? And so I think that defenders naturally are a bit more persuasive when it comes to being a trial lawyer. Now, of course, maybe the facts and the evidence aren't always on our side as much. We didn't bring this case, obviously. So, sometimes you can't overcome whatever you have in discovery before you. But I do think that when you're choosing someone, especially for trial, a former prosecutor, can they flip the script and move from this rote robotic, we will prove these 3 things. Here's a conclusion, ladies and gentlemen, is that compelling? Or is somebody telling you a story that makes you want to like jump out of your chair and cheer compelling. And so I think that that's a significant difference that maybe is not considered. And in terms of the connections, so long as somebody has some experience in the federal court where your case is going to go down, then you're going to have those same connections. Certainly you don't want somebody with a bad reputation, but I think for the most part, if you've spent any amount of years as a federal government, criminal litigator, you can't have a bad reputation and you can't be like mean or unwelcomed in those courthouses. But yeah, I mean, I get it. I mean, I personally would not, I would personally choose somebody who doesn't have it in them to prosecute if I needed representation.
What a great answer. Second question. I am in leadership in the American Bar Association Criminal Justice Section, and there seems to be a schism between the white collar defense bar and the non-white collar defense bar. And I can't help but think that somehow money has something to do with that, because the people involved in the criminal justice section are basically scrapping for money. It's hard to represent people who don't have a budget. And then, of course, there's a white collar bar where people could be equally as in trauma, and it's have all kinds, the same issues are there. They just may look a little different, or at least to the outside look a little different. So how do you make the jump from being a criminal defense attorney for people who perhaps don't have resources to someone who has much more resources, but perhaps it demands a different level of attention?
Yeah, I mean, I think that's a good question. I noticed it as well. I have always a handful of cases in like state superior court, but they're pretty limited to the same type of cases. I do a lot of sex offense defense. So besides those, for the most part, everything I'm handling is in federal court. But of course, I have my colleagues, especially like on the state level with our local organization here, that I see, their practice is entirely different. And I don't know. I mean, I think that, to be honest, I think that white collar work requires a certain level, again, of like academic wherewithal. And you have to be, you have to have some level of experience that kind of allows you to read and write and research and present and be creative, certainly on a level that's the type that can win these cases or that can get the result that you want, one way or another. And I think the reality is what I've seen sometimes in these state courts is like, you don't have judges that are like following the rules of procedure. And they're like, what are you gonna do? Appeal? Like, people don't do the kind of work we do on the white collar level, right? Like, you don't always have people that are going to take like a driving on a suspended license case, to the appellate court. And so I think that maybe the disconnect is certainly money, but it's also, I think, the way that we litigate. And what I would like to see is, and there are certainly some lawyers who are doing this, but on the state level, I don't think that we should stand for like judges who have gone rogue, for prosecutors who aren't following the rules. I think that there's room for us to and that's what I sometimes like to do, for better or worse, is to go to some of these other jurisdictions and take the training that I have, and file things like a sentencing memorandum in a state superior court. Like I did that recently in a jurisdiction where they've never had that done before. I actually brought in local counsel because it was like in a small town in North Georgia. And I was like, should I do this? Should I file this? And she said, yeah, I think this is good. Given our judge and everything else, you always want to make sure that it's appropriate for your audience. But I think that there's room to kind of bring the level of sophistication when it comes to how we litigate these cases to maybe lower stakes cases or courts where you don't have, judges who understand the rules as they do in federal court. But I know the disconnect, and I think it is, of course, first and foremost money, but also it's like how we attack. And I think if you go in there and you've done that research and you are, that kind of confident advocate, I think that only results in like a better outcome for everybody and maybe moves certain jurisdictions away from being like corrupt and dysfunctional. But it is complicated because certainly people, need to make money and they have to hustle for whatever cases they can get. But
All right, last question before we open it up. I think I read that you were involved in a case out in the Midwest. I think that's right. Is that right? Midwest? Were you pro hoc somewhere?
Oklahoma was Joe,
Mhm.
but I think that's the
Yeah,
last.
I think that was it. I think that was it.
Yeah, Oklahoma.
So almost everybody on this call with us tonight has been prosecuted or somewhere in the system. And I can just, I know my crowd. I can tell you a lot of them wish they had hired you. But how is it when you're working, in a team? Maybe it's not the courthouse that you're used to operating in. You need to budget appropriately, find resources appropriately. It could be out of town, and are you available for these things around the country? And is that something that you do or are interested in?
Yeah, I do. I take cases across the country, but I'm really kind of what I referenced earlier about, I think the best lawyers are those who kind of, take the ego down a bit, admit what they don't know, and kind of throw themselves at the mercy of somebody who's like far more knowledgeable about some specific area than they can, ever be in a short period of time. So yeah, I've done some different pro hoc cases. And then also the other interesting thing is I've been local counsel for like big law firms across the country. And it's interesting to see how like I'm perceived as a resource, as local counsel. So certainly the tax trial, we got along famously. It was just so collaborative. Everyone was learning, but I've been in a different situation where I've been local counsel with like a, big law firm and, a major metropolitan city, and they made some mistakes and, didn't necessarily ask. And, had they, I would have told them that's not how we do that kind of, that's not, you have to put the Nixon factors in your subpoena. But anyways, I think that for me, I enjoy taking cases across the country. Obviously the law is the same, right? So if you know federal law, you know federal law. And sometimes, there's something novel going on in your jurisdiction that can be appropriately applied in another jurisdiction, right? And so it's good to have, I think, diversity of thought. But my strategy, if I'm going elsewhere, I rely heavily on the local. And so I think a lot of times people have me come in and they want me mostly for like a trial strategy, right? They want me to kind of think about openings and closings and who, voir dire and these kind of things. And that's, in order to even do that effectively, you have to know about the local population, right? So even when I'm brought in that capacity, I still defer, I always am going to say, whoever is the person who practices day in, day out, this is it stops with them. They have the final word when it comes to making decisions in the case. And I think that if you do it that way, I think that there's a lot of surprises if you don't do it that way. Certainly, I think that, for example, the makeup of the jurisdictions that I frequently practice in, I don't think from the outside looking in, people would expect, for example, the jurors that we get with any given pool, or certain judges' personalities. So yes, I take cases across the country. I've worked on cases collaboratively with attorneys from Massachusetts and Washington, D.C., Oklahoma, Florida, all federal cases across the country. But certainly if I get pulled in, I'm not going to act like a know-it-all and am going to happily defer to whomever is the local and the oracle as to how things are done in that particular area.
Did I do a nice job pitching you out there?
Thank you. Yes.
You're welcome. All right, folks, we're going to open it up to questions, or you can share your experience because we all are in this together. If you'd like to ask a question of Molly or share your experience, please put your name in chat and I will call on you. We're going to start with Tom and then Keith, and we could use more names in chat, please.
Hi, Molly. I was an attorney for 30 years until I wasn't. And just as an observation, as far as prosecutors are concerned, I pled guilty and went to my sentencing hearing. And the prosecutor, I think he really liked the sound of his own voice, but he had to give a long brocade about me. And then my my public defender gave her little statement, and it became pretty clear to me that these people, between the two of them, didn't even really understand the transaction for which I was being prosecuted. And I see you're shaking your head, so I imagine I'm not the first person to have ever been in that situation. But I just going in a whole nother direction, since you're in Georgia, and since I continue to be interested in developments in the law, I was really amazed to hear that this 14-year-old who shot the people in the recent school shooting down there, that Georgia, or at least whatever jurisdiction in Georgia, is going to follow like Michigan and prosecute the father anyway for basically helping his son by giving him the firearm he used. I happen to think that that's long overdue. I'm glad they did it in Michigan, and I hope it's successful in Georgia. But my question is, what do you think of that, and what do you think of the chances are of it?
Well, Tom, I made a TikTok about that about a week ago. So I followed the prosecution of James and Jennifer Crumley in Michigan, and obviously they were proceeding under Michigan state law, which I think the nuances of them, and I knew the attorneys who were representing the parents up there, or knew of them, and followed them as they kind of took it through an interlocutory appeal. And I think the Michigan law, the way it was drafted, it was more difficult because it addressed foreseeability. In a way that ours does not. I think it's going to be much easier for the prosecutors to meet the elements down here. So what he's been charged with is cruelty to children in the second degree, which is a very simplistic statute. And it basically says that if your negligence causes pain or harm to a child, then you're guilty of this misdemeanor, cruelty to children in the second degree. And then we have our homicide statute, which says that if you are guilty of cruelty to children in the second degree and death results, then there's this second degree murder. It's the only degree of murder that we have in Georgia. Otherwise, we just have felony murder, and manslaughter. So it's going to be a novel. Obviously, it is the second ever parent, situation where we have the parents charged for a school shooting. But I can tell you that just looking at the code as drafted, ours is far more straightforward with the elements than was Michigan. And as we know, both James and Jennifer Crumley were convicted. And so I think the likelihood of obtaining a conviction where we have a much more clear-cut statute that seems to fit the facts, I think we can expect, in murder, it's a life sentence. So he's facing life, and it's basically based on this negligence theory, and the statutes line up pretty straightforwardly, at least from my perspective. I kind of predicted the dad was going to be arrested before it happened. I think because we had already, I guess through CourtTV or just through my general true crime obsession, we had seen some footage of him, the dad, being aware, talked to by law enforcement, that his son had been making some sort of threats. And obviously the dad knew he had the firearm. So that seems to be enough for negligence in terms of what I've seen down here. So that's my prediction.
Tom, thank you. Thank you for that question. Up next is Keith, and then Brent, and then Caroline.
Molly, thank you so much. Really enjoyed hearing about all your experiences. And now what I'm going to ask you, I have a lot of curiosity about what goes on in the criminal justice system between the prosecutor and the attorney. The attorney that I hired was very high profile. The second attorney that I hired, after, thank God, Jeff convinced me to look around, wasn't going in a good direction with my first attorneys. But when it comes to, negotiating a plea deal, I've been in business my whole adult life, and I've never gone into any deal without being in the room negotiating. So I wonder what really happens between, the prosecutor and the attorney that's negotiating this. Somehow I feel like if I could have had some input to what happened, there's content in this context, So that there was really never an opportunity to really have any, personal involvement. And it doesn't mean that I should have been, maybe I would have made it worse. I don't know. But, I have confidence in myself that, somehow I would have been able to have some positive impact. So I always wonder, it's like they know each other, they work on multiple cases together. I wonder if there's some horse trading going on, do me a little favor here, and the deal that we're working on for the other guy, I'll give into this. Does that happen, or is this in my imagination?
No, I mean, I think that every lawyer is different. It's so interesting that you bring that up, because I literally had this kind of not heated, but it was just necessary, an in-person negotiation today for one of my cases. And it was after I had already had another in-person negotiation scheduled a week ago. And at the last minute, one person said, oh, I can't come. And they changed it to Zoom. And I was like, oh no, we're not going to, meet over Zoom to talk about this. This is my client's life. And so I kind of demanded this subsequent meetup. And I literally left the courthouse earlier today talking to the deputy chief, right? Which is what I wanted to have happen to begin with. And I think that every lawyer is different. And I think that every lawyer has different kind of goal setting. And so I was talking to one of my assistants today about this case, and she's like, there are some lawyers that would have been happy with whatever you guys talked about over the Zoom a week ago, right? Because maybe their goal is simply to wrap up the case. They can have a cursory conversation and say, well, I'm kind of getting to the end of this matter, and I'm going to convey this offer to my client and tell them that I think they should take it because it's better than trial. But for me, I do think that I think there's a lot of lawyers that are like me, at least I hope there are, that realize that negotiation is not a one and done situation. And that especially if it is not in person, if it's not lengthy, I don't think you can just talk for 10 minutes and kind of hash out all of these issues. But I know that there are different strategies and different styles out there when it comes to litigators. And I do think that some people think the goal is not necessarily to keep pushing until we get to an offer that's reasonable in every respect of the word. Maybe for some people, it's like, I just need any offer that I think is okay. And then I can convey it because the goal for the attorney is to close the case out, right? Like if it results in my case dragging on, which this one is nowhere near done, we're going to have to keep the discussion going. If the goal is to close the case out, you're going to have a far different offer at the end of the day than you're going to have if the goal is to get something that you in your heart believe to be reasonable. But there's nothing that tells an attorney exactly how much to push that envelope, right? I think that some people can easily get into the habit of having a phone call being like, hey, can we do this? No, all right, I hear you, I'll convey it to my client. But there are certainly plenty of us that don't do it over the phone, that don't accept just a short conversation as the end all be all, and that continue to push. And I do think that if you start doing that, what's interesting is that if you start doing that, you realize that it's far more effective and you get better results. And so that kind of motivates you to keep going. But it's I don't like hearing that. And it's especially from somebody who has the business acumen and that kind of experience. I think that all of that would translate well to negotiating some sort of resolution of a case. So I'm sorry that that's how it went down, and it probably, it could have gone better, but my hope is that for the vast majority of lawyers, they're at least thinking about it, not in terms of their schedule or closing out a case or whatever they're doing, but more about the client.
Thank
Do
you.
you think a client should participate in that?
I think it would depend. I don't like the idea of my client being in a room with a prosecutor that then has access to them saying something, right? So that's my hesitation. But I do think that you can engage the client with the lawyer, with the defense lawyer on a level. You can engage with the client on a level that then your negotiation becomes more effective. You don't just say, let me handle this. You sit with them to really understand what their goals are, what they can live with, what they can't live with, what this piece of evidence means to them. And then, you're more informed going into that negotiation. And I think sometimes lawyers don't do that. But yeah, I'm always hesitant. I don't like my client in a room with some prosecutor, that's for sure.
Does that,
Thank you.
Molly, does that mean that you don't like proffer sessions?
I obviously I have to do proffer sessions every once in a while, but I think that I was trained that if, things are going a certain direction, there's no problem with saying the proffer's over, and I think that there's a lot of room in terms of, you got to really know what your 1B1 letter says. And there are certainly times where you say, no, there's no point in doing a proffer session. There are certainly times where you say no.
Is a 1B1 letter federal?
Yeah, that's when you get, you basically get a little bit of a promise that we're not going to prosecute you for something that you tell us that we don't know about, so long as it's nonviolent and it's not covered under this, section. And so, you have to, every jurisdiction does the letter a little differently, but it's our kind of standard proffer letter. And in some cases, I had a really interesting, I think it was like a 10-day proffer for a huge international money laundering case. And that was the right move for that client, but there have certainly been times where I review the letter with the client and we look at kind of where we are in the case, and we either say no, or sometimes in the middle of the meeting, I'm like, all right, we're done. Thank you. We got to leave. So every case is different. And there are times when you got to sit across from the government and say a few things that, it happens.
Yeah. Thank you, Christian. Just to follow up on what Keith just said. What and what you said earlier, Molly, is that a lot of lawyers at the end of a case, they'll write a closeout letter sometimes, and then you never hear from them again. But I just want to let lawyers know out there that in the camps and in our support group, we are talking about you. We are comparing notes. So if information is power, I want to let you know that one of the reasons for the support group is so that we can share information, so that maybe we can change the outcome a couple of percentage points just by having more knowledge. But one of the things, if you're not treating your clients right, we're going to know about it.
Yes.
And that's something that Keith alluded to. So obviously it's not something you have to worry about, Molly, but out there in the world, I'm just telling you we're talking about you.
Yeah, warn them.
Oh yeah. All right. Next is Brent.
Molly, I love your story. I mean, I once I found out you were a speaker, I looked up your Instagram and what you do, and it's so. I wish when we all go through this, we're looking for attorneys like you that have confidence, that have the passion, that believe. You want an attorney to believe. I'm curious because 97% of us we get stuck in this mill of running around and they stack the charges and you end up going and doing your plea bargain. For those who don't do that, and you sit down with them, because you have these discussions as a federal defense trial attorney, and you decide it's a good thing to go forward. And for the most part, they usually win. But not always. But I'm curious, when you have somebody that you feel so strongly about, that you felt like they should have gone to trial, and because of the weight of all the things that happen when those people walk into the courthouse and they have the United States of America versus your client's name, and they lose, I've never been able to talk to somebody that has dealt with that, because what does that feel like when you feel so strongly in your favor and you've done all the things you've done and you are such a advocate, and I can feel it. I'm so inspired by the way that you talk and believe. What does that feel like from your side?
To lose?
Yeah.
Yeah, I think that, my goal, you have to prepare your client. And so one of the things that I've done in the course of running my firm is to be really selective with what I take on. We never spread ourselves thin, and everyone gets a lot of individualized attention. So first of all, the client is informed of the risk. It's their decision to go to trial. I never push a client either way. And if a client is adamant about going to trial, you are never supposed to say that they shouldn't. And at that point, you have to just get into trial mode. But at the same time, you want to inform the client about what to expect as best you can. Trial is always full of surprises, But I think so long as the client's educated enough, there's a lot of empowerment in that. If they kind of know what to expect, as things unfold, they feel a little bit more comfortable through what is otherwise an incredibly high stakes experience. And what I've found, because a lot of times these, verdicts hinge on some strange ruling. The jury's out of the room, and there's like some sort of motion that someone's made, or there's some piece of evidence that we really want in that the judge is not going to let in, and like there goes our defense. And that's how these things turn like that, right? So you prepare your client as best you can, and at the end of the day, what I have found, having tried a number of cases, is that if the client feels like you did everything you could do in the face of perhaps an unfair ruling, in the face of a prosecutor that played a little dirty, in the face of an investigation that doesn't quite seem to be, fair nor just, right? If you did everything you could do as the lawyer, then they feel at the end of the day, maybe not okay with everything, but much better than they would feel if on top of everything else, they feel like their lawyers kind of sent them up the creek. And I've seen that happen. I have seen people, at counsel table visibly kind of fall apart, watching their advocate not stand up and fight like hell, like their life is on the line, right? And so I think that there has to be an understanding that there's only so much that's within our control. It's trial. I'm going to prepare you as best I can as to what to expect. And in the face of what's going to possibly feel like an unjust, unfair result, you'll know that I did everything that I could possibly do within a system that doesn't usually allow you to do everything that you feel you need to or want to or should be able to do. So I think, again, it's about that client relationship that can carry you a long way. And then, then you appeal. Then you you live to fight another day.
Exactly. Right.
Thank you, Brent. Keith put a follow-up question in the chat. Tell us about how you feel about the trial penalty, and is that fair? I mean, is that really forcing people into pleas that would otherwise not do that? And how does that come into your calculus?
Yeah, 100% it's unfair, and it's forcing people into pleas. And I think that, why do we have plea bargaining? Well, it's because we have an overcrowded system. Well, why do we have an overcrowded system, right? I don't think the inquiry stops there. We need to maybe not be so overcriminalized. I don't like when people say, well, there's just too many crimes out there. People are committing too many crimes, so we have to have plea bargaining because of all the crimes. It's like, no. Maybe we need to have a more lenient statutory structure that doesn't criminalize things that maybe are a little bit more in the gray area, right? Or maybe we need to have a less punitive system of punishment that requires mandatory prison time for people that don't need that level of, incapacitation. So yeah, I have a huge issue with the way that the trial penalty, takes people that otherwise would absolutely exercise their right to trial and instills within them fear, and certainly legitimate fear, about having a far greater sentencing exposure. And I think the solution is not so much, people need to stop committing so many crimes. The solution is don't make every single thing a crime punishable by 20 years in prison, right? So yeah, I think that that's a huge problem with the system, but I don't do systemic litigation, so I can't fix it,
Great follow-up, Keith. Thank you. Next is John, and then Jeff.
Molly, that was truly inspiring. You have a great story and wonderful presentation. Thank you so much. In my case, I chose my attorney because he had a good relationship with the prosecutor, thinking that that would enhance my situation, but it didn't work out very well. And I kind of found along the way that actually his relationship with the prosecutor kind of got in the way, that I really felt that that was almost as important to him, and maybe even more important than his relationship with me. And but my question is a follow-up to Keith's, is that, as I understand it, 98% of federal cases, especially white collar, become plea deals. Mm-hmm. And that 98% of cases that go to jury, the Department of Justice wins. And so when you're in this, and it's also very expensive to go to a trial. In my case, my all of my assets were confiscated by the government, so I had very limited resources. And, you know, my attorney said, you know, if you go to trial, you're probably gonna lose. And, you know, if we don't take this plea deal, which was not a very attractive plea deal and didn't work out very well for me at all. So, it just seems to me that this situation that we're talking about, 98% going to plea deals, that there really doesn't seem to be on the horizon to change in the system.
Yeah, I mean, I think that that's, you know, I think it requires more people, you know, saying they're going to go to trial. And you're right, trial is expensive. So then you're kind of caught between maybe the client wants to go to trial, but they can't afford what the attorney is recommending in terms of not just, you know, their trial fee, but also possibly, you know, expert fees or anything else that, you know, comes with trial. And I don't know, is it going to change? I think that the only way that we can make it change is, you know, nobody thought we were going to win this trial last year, you know, like I think that change is slow, right? Sometimes to a level where it can barely be perceived. And I think that there has to be some level of optimism for us to continue to push and hope that things finally do shift. And I think that there have been some changes in terms of the law in recent years that are a bit more defense friendly than we could have imagined like 15 years ago, right? Like when I even was first having to start like the criminal defense societies at Emory, nobody cared about doing criminal defense work, right? And so I think that society has kind of shifted their view of prosecutions and prison in a way that hopefully manifests itself in the coming years as being a bit more fair and having a bit more mercy and leniency for those who are accused. But I think when you look at the numbers, certainly it looks bleak, and it has looked bleak for a long time, but I have to have some sort of optimism. And perhaps I find that in these small shifts in the law, in, you know, kind of some of the recent amendment changes I thought were pretty good, the federal guideline amendments. I have hope that the loss amendment will be dealt with soon. And I think that optimism, if you don't have it, it's really hard to kind of do this work. And certainly, you know, again, you may not hear about them, but there are these cases across the country that are quietly being won by attorneys who were told time and time again from the government, yeah, go to trial, you'll lose. But it's behind the scenes, and we have to maintain some level, I think, of positivity regardless, because without that, there's certainly not going to be any change whatsoever.
I have one follow-up. Is I heard that in some legal corner that there is some process going on about the issue of incarceration plus restitution, that it's a kind of form of double jeopardy. Is there any real progress on that, or is that just pie in the sky?
Yeah. Oh, so, okay. I think that this actually might be something. So these issues, whenever I go to see my NACDL, my National Association of Criminal Defense Lawyer colleagues, usually one of them is pushing this issue. There is always something like that to litigate. And that, I think that kind of stuff is the most important. When you have this like seemingly harebrained idea, right? That's how change actually happens. So I think I know what you're talking about. I have a friend out in Oregon who I think was litigating this, and it might be with the Oregon Supreme Court. It might be, no, he might be doing forfeiture, but there's always something. Just because it's always been done one way in the past doesn't mean that the right motion in front of the right judge isn't going to be this seemingly small thing that does that paradigmatic shift and changes the law for everybody. So yes, I don't know specifically what's being done with restitution and this idea of double jeopardy, but the way that you've presented to me, it seems like legally plausible that we shouldn't be doing that. And obviously, I'm hopeful that someone is kind of preserving it in such a way that it can matriculate through the appellate courts and do some meaningful change in terms of the overall system.
Thank you.
Thank you, John. As a follow-up to that, Molly, I think that communication between people who've been through the system and lawyers and learning more about one another is very important. I mean, one example in the forfeiture and restitution arena is that we had a group member who whose restitution hearing was scheduled, but it was scheduled for after he went to prison. So what I don't know if lawyers understand that if you're going to take your client out of prison and have him come to that courthouse, he could be in diesel therapy for 90 days in shackles on airplanes, in buses. And if you have a relatively short sentence, let's say you have a 1-year sentence, you could spend 3 months of it shuttling in and out of solitary and in county courthouses. And at the end, and the system, it seems, is set up to be painful.
It is.
And so how do you weigh those things as to what's actually in the client's best interest, as opposed to what would be doing the most for the system in general and moving things forward?
Yeah, I think, criminal defense lawyers, we represent one client at a time, and there are certain things we have no control over. So again, what you have to do is educate the client as best you can. I use a lot of like consultant groups, there's a lot of resources out there if you just, if lawyers, just avail themselves to them. And you try and educate the client as best you can. And you also explain that there are going to be so many things outside of your control, like whatever the U.S. Marshals do, as insane as it sometimes seems in terms of this transport. I can't change what the U.S. Marshals do, but I think that what compounds that, the frustration often comes from a client being shocked that any of this is happening and no one has explained it to them.
Right.
And so I think that what you do as a good lawyer is you have to have a good understanding of the landscape to explain what could possibly happen, the different permutations of, ways that this hearing might completely disrupt the entire, how you're serving your sentence, and explain all of this to the client and try and do what you can to advocate for their interests. But again, I think the worst thing you can do as a lawyer is be dismissive or disinterested in that kind of suffering as it's happening. And that's something that I have seen time and time again, where a client, maybe, like, for example, there is some sort of issue with wherever they're being detained or with transportation, and people just, they throw their hands up and they say, oh, I don't do that. I can't do that, and I think that that's an inappropriate response to somebody that you are tasked with zealously advocating for. Even if there's nothing that you can do, you can't act as though you're completely disconnected from that problem and it's not your problem as well. So maybe you can't change it, but you should at least make the person feel like they're being heard.
Yeah, good for you. All right, we're going to go to Jeff, and I think that'll be the last question for the night, and then we'll wrap it up, okay?
Hi, Molly. I really enjoyed the session. My question, I want to pick up a thread that I think Brent had put down, which is, if you have a client who is, I didn't do it, I'm not guilty, this is all invented, that's sort of easy. You can go at that and you're like, you want to take this to trial? We can take it to trial. When you have a client, though, and this was my own personal situation, that did something wrong, right? Did something bad, sort of caught red-handed in the sense, like the mountain of evidence against that person, and the prosecutors are now overreaching. And maybe their motivation is they just feel like in their heart of hearts, because they're, that this person deserves more jail time than the guidelines for what they did would require. Or maybe they're trying to make a name for themselves in the office, or maybe they want a bigger press release or whatever it is. And going to trial really isn't an option, because for sure that your client will be guilty of a couple of things, and they're going to throw a bunch of more things on. And sometimes juries, once they decide this person's bad, they do everything. What kind of approaches have worked for you in the past? What techniques do you have to walk this prosecutor back from overreach when you don't really have the leverage of saying, well, then we're going to go to trial? I mean, what do you do? I'm just curious, in your experience, have you encountered that, and what approaches and techniques, have you used that have been successful or not successful?
Yeah, it's a good question. I certainly have encountered that. I think that that's a bulk of my practice. And I think that what you have to do is, you're not just considering the charges, what they can charge. I mean, that is the vast majority of prosecutors. If they have an opportunity to make a name for themselves and overcharge, it's easy for them to choose from an assortment of statutes with which to enhance a potential sentence. That's easy for them. And certainly there's a lot of them that take that route. And I think that what you do is you don't think just about the charges and the evidence and the accusations. Then you kind of flip it around and there's this whole other side, right? The person. And you hit mitigation and negotiation as hard as you would investigation. You know, I believe in like very in-depth investigations. I work with former FBI officers and, you know, we do that level when we're trying to attack something factually. But if the facts are the facts and we're trying to move somebody, then you kind of switch gears. And I need to know every single thing about you. Sometimes I hire a mitigation expert. We're going to interview everyone, you know, that is conceivably has some relationship with you. And you try, and I like to believe that even the most cold-hearted, calculating prosecutors have some empathy deep inside them. And if you present your client as a person and you move away from what they've done and talk more about who they are, that's when you actually get some leverage back. And so I've done huge mitigation workups where, you know, I have a case right now where the client, there's nothing we can do in terms of the facts. I mean, the facts are the facts. But what we can do is, you know, I go to like see his elderly father on the farm and film him with my little crew and put together this video that I think is like really compelling. And yeah, it has nothing to do with his charges, but I know the prosecutor and I know that she's going to like it, you know? And I think that there's a whole other narrative to tell. Nothing happens in a vacuum, right? If you're just talking about the charges, I think you're missing a huge opportunity to negotiate a case.
Jeff, thank you. And Molly Parmer, thank you for being our guest speaker tonight. For those of you who are watching this after, we are recording this on September 10th. So right after this, we're gonna have to watch a debate between candidates on the national level, but I'm sure it is not going to come close to the level of this conversation tonight. So thank you for that, Molly. A quick pitch: our White Collar Support Group is on Monday nights. You can learn more about us at prisonist.org. Our White Collar Conference is on October 19th at whitecollarconference.com. And you can reach Molly Parmer at, you should plug yourself, Molly.
Sure. Well, you can email me, molly@parmer.law. My website is www.parmer.law. I'm TikTok, Atlanta Lawyer, and then Molly Parmer on Instagram and Facebook and all of that. Tomorrow night, I'll be on Court TV, 8 p.m. Eastern Standard Time. Reach out. It's been a pleasure, Jeff. I love what you do. I love this kind of conversation. You are all the reason, you know, that I get to have the most incredible and most important job that there is. So thanks for having me. It's been a joy.
Thank you. Thank you, Molly. Blessings to you. Blessings to everyone. And we'll see you next time. Thank you.
Bye.